Okay, good morning. Welcome to the 2020 annual meeting with the bar. Thank you for joining us today. Lots has happened since we last met in November of 2019, and the future is not entirely certain, but I hope after today's presentation, you'll have some good information about how to move forward. I think we're having a little technical adjustments. Here we go. So a few general comments. If you're attending online, please notice the chat box on the bottom right hand of your screen. This is a private chat that you can send questions about the presentation or if you need technical assistance. If you are participating by telephone, you are in listen-only mode. You may send general operational questions, and you can use this email address anytime, and that's to info@ganb.uscourts.gov. One other quick comment about access: if you are having trouble using Internet Explorer to get a full, either the chat box or the full image, you might want to try using a different browser. The announcement was updated just a little while ago to say that, but you may not have had a chance to see it. If you do not already receive public notices and announcements from the court, please be sure to register through the court's website. There is a tab in the center of the home screen that just says email updates. And if you click on that and put in your email address, you will receive all of the public notices for all issues that are generated by the court. Today's presentation and the PowerPoint will be available on the court's website in a few days. And finally, my thanks to the judges and staff of Georgia Northern Bankruptcy, who have weathered the challenges of COVID-19 in amazing fashion. I am proud of how our court, and really bankruptcy courts throughout the country, have been able to adapt and move forward to help those in need of bankruptcy protection during this very difficult time. I am grateful to Chief Judge Hagenaw, also known as my partner in crisis, and all of our judges for putting the health and safety of the court staff, the bar, and the debtors front and center while we continue to do the business of the court. So, keeping in mind that today is Friday the 13th, 2020, and what could possibly go wrong, let's begin the presentation. I always like to begin giving you a little idea of the statistics, both locally and nationally, for bankruptcy filings. Georgia Northern Bankruptcy, for quite a few years now, has been the third busiest bankruptcy court in the country, but we took a little slide down to the fourth spot for the 12-month period ending September 30th. We had 21,909 cases filed in that 12-month period. That's a low number, and I don't need to tell you on this presentation, listening or viewing, that filings are way off, both here in Georgia and around the country. California Central is the busiest court now at 31,000, but just to give you some perspective on that, just a few years ago, they had over 100,000 filings in a 12-month period. Illinois Northern is second at 29,940, and Florida Middle, our 11th Circuit colleagues, moved up a spot. We flipped third and fourth positions, and they're at 22,612. Just again, for perspective, the highest filing in Georgia Northern was in calendar year 2010, and we were over 54,000 cases. For filings per 1,000 population, we are the 10th highest court in the country at 3.11 cases. And for pro se filings, we are 22nd in the country with 7.2% of all of our filings being filed by pro se parties. A little bit about the budget. It's always on our mind. Not surprisingly, we started the fiscal year 2021 under a continuing resolution, which ends at midnight on December the 11th. It was always likely that there would be another CR to continue the operational year, but with the election and what appears to be a change in administrations, I think is a certainty that we will have at least one other CR. One thing to keep in mind, and we always mention this both to our staff and to the external users, that the federal judiciary does not get all of its money through congressional allotments. We have non-appropriated funds, mostly through filing fees, that allow us to continue operations even if there is a partial government shutdown. Because most of those come from filing fees and filings are down, it's a little dicey for how long we can continue to operate normally. But I think it's safe to say come December 12th, if there's no budget or another CR, we will be open for business. That's the intent. A little bit about COVID and the court. The first public notice that we sent out about the pandemic was March the 9th, 2020. Since that time, we have done 12 additional notices, postings. There have been general orders. There have been all sorts of activities from the court since March the 9th. As you well know, for a period of time, meetings of creditors were postponed and associated deadlines were extended. Now the meetings of creditors are being held telephonically. I understand that is going well. It's been a successful accommodation, which is good to hear. While most of our court trials and hearings are still being held telephonically or via WebEx, we are seeing an slight increase in the number of trials or contested matters where the judge is bringing in some parties into the courtroom on a limited basis. I think most of our judges have done that at least once. We have set up all the types of security and safety protocols you would expect. We have plexiglass, we have microphone covers, we have hand sanitizers, parties are spread out through social distancing. It's been successful. And I think you will see a little bit more of that coming up in the next couple of months with filings expected to increase after the first of the year. And we keep hearing words like tsunami of bankruptcies. I'm not sure about that. But I do think with the increase in filings, you may see more and more limited participant in-person matters being heard by our judges. For staffing and operations for the court, I'm proud to say that we have been able to keep our doors open to the public. We, with very few exceptions, we did have a few days or weeks in Rome and Gainesville where, because of a positive test, a COVID test, not by our employees, but by other employees in those buildings, the building was closed for cleaning and to allow proper sanitation of the building before parties were let back into the building. So aside from those few exceptions, we have been able to keep the doors open, both for public use and for, of course, our staff. We do have a majority of staff teleworking on a daily basis, but we do have staff in the building in each of the 4 locations every day. Not sure what the future looks like for the court or certainly for the country. We think we have been able to accommodate the needs of all of those who need access to the bankruptcy court. If there is something that we haven't done, I would like to know, because we do want to accommodate and we want to keep access available to everyone. So if there are things we have not done or information that you think has not been completely or timely shared to help you, I really do want to hear from you. And you can call me, you can email, you can use the info at GANB email address, but we do want to know, because this is our job. We want to make sure we are accessible. So moving on to more operational issues, we do have some changes upcoming to the Chapter 13 plan form and related general orders. This has been a work in progress over the past several months. A lot of parties participated, and I'll talk more about that in just a moment. But there will be a revised Chapter 13 plan form effective December the 1st, 2020. It will be made public very, very soon. Along with that, several general orders are being revised to accommodate the changes that are made by the Chapter 13 plan. I'll talk about those, an overview of those changes in just a second. The order that requires the Chapter 13 plan form and the related procedures has been updated. Order regarding fees and expenses and costs for attorneys representing parties in Chapter 13 has been updated. The voluntary notice procedures general order has been restated. It's not a new order, but it's a restated order to include additional Chapter 13 attorney's fees. And then the post-confirmation modification document that's on, I think, all of the judges' websites changes the notice period from 30 days to 25 days. So what's changing with the form? When we publish the form, it'll probably be next week. I'm also going to publish a document I created that it's a side-by-side comparison document. So it'll tell you the section, the current language versus what the change is, so that it's clear, and you don't have to go hunting around in the plan form for what's new and different. So this comparison document will be released with the plan form. But a few of the highlights of that, the word timely has been removed from the plan when referring to those who can participate in distributions in a plan by the filing of a proof of claim. On page 1 of the plan, the DSO obligation section has been moved, and as you well know, at the bottom of that page 1 is the box that has several items that say included or not included in this plan. So DSOs has been moved to that box, so there's actually an affirmative checking of it is included or it's not included in the plan. In section 2.3, the word federal has been added 3 times, making reference to federal tax returns and federal tax refunds. In section 2.6, A and B has been deleted, and that's been commonly referred to as the waterfall provision, where it says how the distributions will be made by the trustee under the plan. That's been removed, so it shortens the plan by probably almost a page, and it refers to a new general order that will detail that same language with some minor tweaks in a general order. And language has been added about the interest rate to be used for secured tax claims. In section 3.3, there are changes regarding the secured claims to be paid in full and reasons why that would be proposed by the debtor. Section 3.4 is the lien avoidance section, as you know, and it's a large box with lots of information to fill in. The current box will be removed and a smaller, a little bit more simplified calculation box will be added, is added, and that will be part of the new plan. In section 4.3, there has been a reference made now to seeking additional attorney's fees, and that ties in with the voluntary procedures, notice procedures on how those can be claimed through that process. Section 4.4, it's been reorganized and reworded to clarify whether the plan has party claims other than attorney's fees, whether they're owed and what they are. And I think it's a good change, I think, to kind of conform with other sections of the plan. And the signature box at the end of the plan has been changed to reflect that if the debtor is represented by counsel, the debtor or debtors only need sign the initial plan. They do not need to sign amended plan. The attorney does, but not the debtors. And that goes along with prior general orders that was entered earlier about required signatures. So at the end of the day, I hope that when you see the plan form and you see the comparison document, you will feel good about the fact that the court listened to a lot of the suggestions and has taken some steps to make sure that the plan is a little simpler, a little shorter, and a little easier for not the attorneys. I know you understand it, but maybe for your clients to understand it. So that will be coming out. I think that will be posted probably next week, early next week. Okay, so we'll move on to a topic that I've mentioned a few times in prior meetings, and it's always been sort of aspirational, but now it's really going to happen. And that is something that is called the next generation of CMECF, or is commonly referred to as NextGen. This is a program that has been developed by the AO and has been out there for many, many years. It's taken a long time to get to the point where they are now, which is to have all court units, whether that's bankruptcy, district, appellate, any other federal court types on NextGen by next year, the end of next year. So right now, as of November the 1st, 106 court units are live on NextGen, and that includes 42 bankruptcy courts. Another 41 court units are going live. They have a go live date, and Georgia Northern Bankruptcy is one of those courts. Our planned migration is the weekend of August 6th through 8th, 2021. And I know that seems like a long time off, but it's really not. There's a lot of work to do on the court side and really the IT side. Most of us internal users and certainly the external customers of the court won't know that a lot of this is going on, but there's a lot to do in the background. But we will be ready to migrate, and we are migrating the same weekend as Georgia Middle Bankruptcy, and we did that intentionally. We spoke with their clerk and their staff, and we decided that since some of our attorneys practice in both districts, that it would be convenient and appropriate for us to migrate at the same time. So they will also go live when we do in early August. So exactly what does NextGen mean? There are several modules that have been developed for the NextGen. Some of them are on the court side only. Really, external users won't see anything different. But all the modules except for one are discretionary. The one mandatory module for all NextGen courts is something called Central Sign-On. And that allows public filers and court users to have one login and password through PACER for all NextGen courts. So if any of you practice in the district court in Georgia Northern District Court, you have already had to do this. They are a NextGen court. So you've already had to update your login and password through PACER. If you happen not to practice in the district court here or other courts around the country that are NextGen, you will not have necessarily done it yet. But there's a centralized PACER website where you go in and update your login. And what's different about this is that you have to have a unique PACER login and password through this to do Central Sign-On. So if you're a law firm where you have multiple users in your office using one CMECF login and password, that will change. And we are going to reach out. We don't have a lot of those anymore, but there are some and some bigger firms. So we will be reaching out to those firms to say, you need to start doing this and working on this so that there are unique login and passwords. We, of course, will have lots of information and assistance between now and August, public notices, which is why you want to be sure to sign up for the email updates. And we are here to assist in this process. It is not a difficult process. It's just one that has to be managed carefully so that when we flip the switch and go live, you're ready and you have access. Another module that is not mandatory, but I believe we will use it, is something called ESR, and that stands for Electronic Self-Representation. And what this is for parties that are not represented by counsel to submit documents to the court electronically. What's different about this than what we have done through the pandemic to accommodate pro se parties through email addresses is that they are actually using the official forms to fill out the information, submit it to the court through the ESR program. It doesn't go on the docket. There still is a level of review and quality control, but if it is approved to become a filing on the docket, it is already in the required official form. So it takes out that middle step of court users having to manually input data that comes in through scanned or emailed or paper documents from non-represented parties. So this may not be a huge help to the attorney filers out there, I understand that, but it's an excellent program for the court to use, and it does continue to provide equal access to parties who need to file bankruptcy. So that's probably one module that we will use and make that available to parties, pro se parties. So lots more to come about NextGen, but just keeping in your mind that August of 2021 is when it's going to happen. So just some general information, and these are all on our website under the news and announcement section to the right of the home screen. When we do a public notice, we post it on the website in that news and announcement section, and of course it gets emailed to all parties that have signed up for email notice and CMECF users. There have been lots of these news and announcement postings since October. And I've listed the ones that are most, I think, important to remember in the PowerPoint, but they're all available on the website, and you can go click, and the date of the notice is listed in the PowerPoint, so you can go right to that date. You can go to the archive section of news and announcements and find any of these. But starting in October, we announced the Unclaimed Fund Locator tool, and that is a program that any bankruptcy court who is on JFinCES, which is a financial program, and we are on that program, it's a centralized location for all unclaimed funds in the country. And so if you're any party, it's on through the website, you don't have to be a registered user of any kind to see it. You can put in the name of the entity, and it's been tweaked to be pretty user-friendly. So in the old days of this program, if your client was Ford Motor Credit Company CO period, you had to put it in exactly, or you wouldn't get a whole bunch of related names for Ford Motor Credit. And now it's very user-friendly to sort of pull in all of that information. So it's a heavily used program out there by, as you would imagine, unclaimed funds locators, attorneys, and parties to see, is there money in a bankruptcy court in the unclaimed funds is still available. And unclaimed funds is a huge dollar amount for bankruptcy courts around the country, certainly for Georgia Northern. And the goal is to have people claim and receive money to which they're entitled. And of course, there's a whole process for that, to do a petition for unclaimed funds and get an order, and we can pay it out. But the money's always there. So literally in our Georgia Northern bankruptcy unclaimed funds bucket, there are funds back there through going back to 1974. They're always there, and there's really nothing by statute that allows that money to go anywhere else. It has to stay in the unclaimed funds. It goes to the Treasury, but it's still designated as an unclaimed funds. In October, we did a public notice regarding distribution lists and the requirements of Bankruptcy Local Rule 9013-2 for proposed orders. We were having some issues with how the orders were coming in and whether distribution lists were attached, and if they complied. I think that has gotten better, but I do ask that you refresh your memory on that and make sure so that we don't have to return orders. We don't like to go back and forth, and I'm sure you do not either. In December of 2019, General Order 29 was issued, and that set up procedural guidelines for prepackaged and pre-negotiated Chapter 11s in the Northern District of Georgia. In February of 2020, there was a general order that talked about the applicability of the interim bankruptcy rules for cases filed under Subchapter 5 of Chapter 11. And we've had probably, I think it's about 35 Subchapter 5 cases filed in the district so far. In April of 2020, there were two two general orders regarding the CARES Act and how that impacted Subchapter 5 and changes to the official forms. Excuse me. General Orders 37 and 38 pertain to signatures, retention of, use of, wet signatures, that kind of thing. And those general orders are, of course, still posted. Even if they're superseded, presently, our general orders list through the website shows the orders that are superseded with a designation directing you to the current order. That may change soon, where we separate those lists and have a superseded order list and a current list, but for now, you can actually see them in numeric order and what has been superseded or vacated, however it might be. In July of 2021, there was a General Order 39 that announced the designation, the change in the Chapter 11 complex Chapter 11 panel beginning February 1, 2021. As you know, for the Atlanta Chapter 11 complex cases, there's a two-judge panel. Right now, it has Chief Judge Haganaw, Judge Bonifel. Starting February 1, 2021, the panel will become Judge Haganaw and Judge Sacca. In July, General Order 40 was entered, which changed some of the filing options for pro se filers. And this goes back to the beginning of the pandemic, when the court was concerned about non-represented parties having access to the court. Even though our public counters were open, there was a concern about, one, bringing people to the courthouse, two, having our staff around people coming to the courthouse, but wanting to ensure that there was equal justice access for all parties. So the court allowed certain filing options for unrepresented parties. So we were receiving documents via email, excuse me, from debtors, creditors, and other parties, whether it was for a main case, an AP, or an appeal. So in July, at the end of July, this General Order 40 was entered, which restricted the access to unrepresented debtors. So now we do not accept email filed documents for appeals and other matters. It's strictly for pro se filers. And in October of 2015, we announced a new payment option for fees due to court through pay.gov. And I just want to clarify, although I only had one inquiry about this from a government entity, because the pay.gov option, and again, it's just an option. It didn't change any of the other ways to pay through if you filed a case as being a CMECF user. The concern was we weren't going to accept credit cards anymore, and that is not the case. For filing of cases through a registered user, of course, credit cards are accepted. The pay.gov option, which has primarily been used by pro se parties, allows the payment of fees, but through a debit card, an ACH, or just PayPal. Sorry, I had a momentary lapse there, or through PayPal, but you can't use a credit card. The pay.gov credit card option is not available in this limited filing option. So we have had debtors paying fees through this. Parties can request copies or transcripts. It's a really good opportunity to do an easy pay kind of system, and we hope you will take advantage of it. So I do encourage you to go back and look at the news and announcements and the general orders, of course, because I'm really just hitting the highlights of what is out there. Some general news and announcements and reminders. This one I've talked about before. Many of you may have been have received emails from me regarding missing 1328 statements and or financial management certificates. This we started, I don't know if it's been 2 years yet, a year and a half ago, maybe 2 years, in Chapter 13 cases where we just want to, our goal is just to help debtors get a discharge. If you get to the end of your case, all you need to do is submit a financial management certificate or do your 1328s. We want to remind you, we want to try to help you. So I have sent hundreds and hundreds of emails and letters to pro se parties saying, we're ready, your trustee has filed a notice of plan completion and a final report. All we need is this or that or both. And of course, represented debtors, the email goes to counsel. And we've had really an amazing response to those. Probably 70% of the time we're able to get those cases discharged. I started doing that in Chapter 7s earlier this year, I guess, for the financial management certificate. And again, probably 75% of the cases, the financial management certificate is filed, even by pro se parties, and we can discharge those cases. I say all of this to say it's a lot of work for the court to do this in the follow-up, for the clerk's office, I should say, and the follow-up. We think it's worth it, but I do see a pattern of maybe the firms that, and it's not necessarily related to the number of cases that are being filed by that firm. So I would just ask you maybe to check your closing procedures or your case management systems, or however you do reminders, that in a 13, when you see that a trustee has filed a notice of plan completion, if you have not already contacted your client about doing the 1328 statements, that would be the time to do it. And of course, the financial management certificate as well. And just again, a reminder that if it's a joint case, it needs to be separate 1328 statements. I think you know that. Another thing we talked about before, and that's a reminder to flatten your documents before they're filed. That has gotten, I will say, a lot better. We did a lot of checking on that because we were, especially for the plan, Chapter 13 plans, if they were not flattened, we do not serve them. And you want us to serve them if you file them within the requirements. So be sure you flatten, and that's a simple process. Instead of saving a document to PDF, you print it to PDF. That means it's flattened. That means people can't change it. And it means people can't see what you have changed. So please, if you don't have that as part of your everyday practice with your staff, I ask you to do that. You do need to keep the court informed of your email address and your mailing address, and you can send that information through the ECF help desk. And that email address is in the PowerPoint. And I always plug our online procedure manual. And I had very little hand in writing it. I supported the creation of it. And so many people have put in an amazing amount of work on this document. And I like to say in our meetings, it's a thing of beauty. It is a living, breathing document that is updated continuously. It tells you exactly what events to use, the rules associated with those events, exactly what you're picking in CMECF when you file them, the documents. I just think if you get in the habit of using them, the online procedure manual, you will realize what a great tool it is. So to the extent you're not using it, you might want to try. One note about our bench and bar committee, which is they just do excellent work. This year, because of COVID, it interrupted what had become a great series of interesting and informative lunch and learn programs. We hope to be able to resume that in 2021, but I thank the members of the committee who have stayed around and tried to help. And one of the big projects, and this is I should have probably put this back when we were talking about the plan, but a subcommittee of the Bench and Bar Committee worked on review of the current Chapter 13 plan form, and they proposed excellent proposed changes for the court to consider. I think I remember everybody on that subcommittee, and I will apologize in advance if I forget you, but Nancy Whaley, Melissa Davey, Ed Saphir, Michael Pugh, Susan Sine, and Dan Mecci, I think, were the six. And then we had some other attorneys who reviewed that after changes were made or proposed and gave some commentary. But we thank you so much. That was really a genesis for how the judges were going to look at changes. They may not have accepted every proposal, but they certainly considered it and discussed it, and of course had some ideas of their own. So the Bench and Bar Committee is a real value to our district, and I look forward to 2021 and seeing the things that they can do for all of us, because they're there to represent you. And on our website, there is a tab for Bench and Bar Committee. It lists the membership with the email addresses, so feel free to reach out if you don't want to reach out to me or to the court. And one other very important piece of information before we start talking about the few federal rule changes is a momentous event, I guess, for the Georgia Northern Bankruptcy Court. On January 31, after more than 50 years of amazing service to this court and the bankruptcy system in general, Judge W. Homer Drake Jr. will leave the bench. And, you know, he's been retired for a while, but on recall status for 10 years. Please save the date, January 22nd, 2021 at 2 p.m. We're going to have a very special virtual celebration to honor Judge Drake. But we will have some changes in the Noonan Division and cases filed in the Noonan Division. So on February the 1st, Judge Drake's pending Chapter 7 and 11 caseload will be reassigned to Judge Bezier. And any new sevens filed will be initially assigned to Judge Bezier. New Chapter 11s, we already made that change for Chapter 11s a couple of weeks ago. So a new 11s being filed now are already being assigned to Judge Bezier. On February 1st, Judge Drake's pending Chapter 13 caseload will be reassigned to Judge Richie Craig. And any new 13s or 12s, I don't think there are any 12s right now, but any new 12s would be assigned to Judge Richie Craig. There will be no change in the Chapter 7 and 13 trustees in that division. So while we're happy that Judge Drake can finally, after so many years of working so hard for everyone, can maybe take a little break, for many of us, we have not known Georgia Northern Bankruptcy without him. And so it is a big change and an important change, and I look forward to celebrating him on January 22nd, and we'll send out lots of information about how to do that so that you can join as well. So before I go to the federal rules, I'm going to ask my team that's in this room with me, are there any questions that we need to answer? Y'all have been handling, I see lots of chats as we've been going on, so great. So we will move forward. This year, for December 1, 2020, there are very few federal rule changes, which is nice. We've had enough going on in 2020. I think there are lots of them for 2021, so we'll deal with those in a year from now. But the few changes now involve Rule 2002, and this is a very high level. I'm really not getting into detail. Let me go back once because I want you to see that at the bottom of this slide, there's a link to the actual page on the U.S. Court's website, the rules and policies page that has all the information about these changes, the committee notes, the letters that go back and forth between the Chief Justice Roberts and Congress, so that you can see the background of how these rules develop. And it is a 2 or 3 year process before they actually make it to Congress. And if Congress takes no action, they become effective December the 1st. So for this year, Rule 2002, the changes are one, a requirement that notice of entry of a confirmation order is sent to all parties in a Chapter 13 case. We already do that. So we actually send the confirmation order. So that's no change for us. There is a provision to limit the need to provide notice to creditors who do not file timely proofs of claim in Chapter 12 and 13 cases. It already exists in Chapter 7 cases. And then there's some other cross-referencing about deadlines for confirmation of the plan. And it impacts several other rules, which I've listed on this slide. So this really is not a big change for us since we already serve the plan, the confirmation order. Under Rule 2004 examination, there is a change they've amended subsection C to add or electronically stored information to the title. So it's expressly referencing the production of electronic information in addition to the production of documents. And this conforms to the current provisions of Civil Rule 45, which is applicable through Bankruptcy Rule 9016. On Rule 8012, corporate disclosure statement. Actually, the word corporate will be deleted from the rule, from the title of the rule. And it conforms the rule to recent amendments to the Federal Rules of Appellate Practice 26.1 to encompass several things, including non-governmental corporations seeking to intervene in an appeal, and in subsections B and C for some disclosure requirements. So that's a change. I think the next slide might actually have a mistake. It says Rule 2002. I think I just have it. We'll fix this before we post it. I think that's just a page that got out of order. So we'll skip that because that's a duplicate. And there should be a slide for Rule 8012. And I am sorry at this moment, I cannot tell you what that change is. But I will update the PowerPoint, and I apologize for that error. I'm just drawing a blank on what that change is. So for 8013, I'm losing control of my clicker. Hold on. There we go. I'm back on track here. Sorry about that. 8013, motions and interventions. This is a change to A1 to delete the reference to proof of service, and that conforms to the recently amended Rule 8011D. And basically the service is being accomplished through the court's electronic filing system. And that is the same for Rule 8015. It's the same. Amendment G to subsection G is the same thing about proof of service. And the word corporate is deleted before disclosure statement, and that is consistent with what we just talked about under Rule 8012, that corporate was deleted from the title. And Rule 8021 under costs, again, it's just conforming all of these sections to delete the reference to proof of service when that is accomplished using the court's electronic filing system. So you can see there's not a lot of significant changes or form changes for us. And again, I apologize for the one error slide, and we'll fix that before we post it. There are also a few miscellaneous fee changes effective December 1, and we've already sent out a public notice detailing what those are. There's not significant dollars, really. It's a couple of dollars here, a couple of dollars there. The one that is important in the bigger picture involves the administrative fee associated with filing fees in chapters 7, 12, and 13. That administrative fee went from $75 to $78. And so we have changed, a new general order is going to be entered along with several others next week that changes the first installment due under anyone petitioning to pay an installment. It increases it from 75 to 78. So that administrative fee, which leaves the court, that goes to other parties and other entities, that can be collected through the first installment and not piecemealing it through the subsequent installments of filing fees. So all related orders that get entered and notices that get entered regarding installment payments have already been changed to conform to this. And the fee chart that we maintain on our website, that will also be changed effective December the 1st. So those are our rules and fees changes. Any questions that have come in that we need to answer? Y'all are getting them all quickly. I see that. So, okay. So just a couple of general announcements and we will be done. Just a reminder that even though it hasn't felt much like winter yet, any weather delays or closings of the clerk's offices in any of the locations, our official notification goes out through our website and through WSB radio and TV. So that's where you would check to see if the court is delayed opening, if the court is closed, or any other kind of announcements, of course, and our website. That would be more detailed information about particular mass calendars or hearings. As you know, the U.S. trustee is responsible for 341 meetings. We don't always know if changes to our operational hours is going to be the same as the U.S. trustee. If it is, we try to include that in our announcements, and we will continue to do that going forward. But if you don't see any reference to meetings of creditors in our announcements, it means that we don't have the information or that there is no change. Last year, I talked about the construction all around the Russell Building, the viaduct project, and it was supposed to be finished. And as you might imagine, the pandemic has affected lots of things, including people's ability to work on that project. So something that was supposed to be done last December is now going to be supposedly finished in, I think, September 31 is the new goal date, 2021. It may be before I retire. I'm really not sure. But at some point, maybe it'll be finished. As we previously stated, the recording of this meeting and the PowerPoint, which I will correct, will be made available through the website in the next couple of days. Before we sign off, my crew in here with me, anything that I have missed or that we need to say? Nope. Well, thank you for attending. I hope you found this helpful and the information helpful. Remember that you can submit questions through the info@ganb.us courts email address anytime. But don't make it case specific. It's about a case that needs to go through regular channels. That is for operational issues, and we will respond quickly. So a happy Thanksgiving to you and yours. Please stay safe, and look forward to actually seeing you sometime in 2021.